Good afternoon, class, and welcome once again to Criminal Procedure. We are now on Rule 113, or arrest. Our intended learning outcome this afternoon is to define arrest, to know how arrest is made, to know what are the duties of the arresting officer, the concept of execution of warrant, when an arrest without a warrant is lawful, what is the time of making arrest, the method of arrest by officer by virtue of a warrant, method of arrest by officer without a warrant, method of arrest by private officer or private person, and the right of officer to break into the building or enclosure, as well as the right to break out of the building or enclosure, and an arrest after an escape or rescue, and the right of attorney or relative to visit person arrested. So let us now start our discussion. So how do we define arrest? We will read together sections 1 and 2. Arrest is the taking of a person into custody. The taking of a person into custody in order that he may be bound to answer for the commission of an offense. Now, how is an arrest made? It is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. And remember that no violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. Now remember that arrest may be made with a warrant. Kung with a warrant na, that's under Section 3, or without a warrant under Section 5 of this rule, okay? So, unsa man day purpose why a person is arrested? Ang purpose why a person is arrested is for the specific purpose, that's the only purpose. Specific purpose of making him answer to the commission of an offense, okay? So under Section 2, remember also that kung mo-arrest ka, a person need not be actually restrained by the person making the arrest. Under the rules, a submission to the custody of the person making the arrest already constitutes an arrest. So kung magpahibaw ka, you're arrested, you are under arrest for a particular commission of a crime, and then wala lang na siya ng laban, sige, sud na lagdiretso sa patrol car, okay ra na, that's okay. Because ang iyahang voluntary submission to the custody of the person making an arrest already constitutes an arrest. Na may uban nga mga police officers nga mga buutan di nila gustong pakauwawan ang kanang mga person nga gi-arrest. So ilalang hunghungan nga you're under arrest, you have a warrant, so and so. And the person being arrested is also very cooperative, so musakay na lang siya diretso sa patrol car. In fact, there are also other officers who will make an arrest nga kanang di gani mag-uniform para di kayo makahatag og skandalo. So that's okay. As long as the person arrested already submitted himself to the custody of the person making an arrest, that already constitutes an arrest. Okay? Note nga naay mga special persons who may not be arrested. Okay? Kinsa man these are the members of Congress, okay? Under Article 6 of the 1987 Constitution, ingon dira nga a senator or member of the House of Representatives shall, in an offense or in all offenses punishable by not more than 6 years imprisonment, okay? By not more than 6 years imprisonment, be privileged from arrest while the Congress is in session, okay? Pero dapat ang qualifying nga phrase is while the Congress is in session, and also note that it should not be more than 6 years, okay? Also, no member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any other committee thereof, okay? Kanang privileged speech nila, they will not be held liable for whatever they say during ana nga speech, okay? Also, mga heads of state, diplomatic officers, and their duly recognized or registered domestics are likewise immune from arrest, and a violation of this immunity will render the arresting officer as well as those who procured such arrest criminally liable. Okay? Now, unsa may mga requisito for the issuance of a warrant of arrest? What are the requisites for the issuance of a warrant of arrest. Under Section 2 of Article 3 of your Bill of Rights of the 1987 Constitution of the Philippines, niingon dito nga, no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Balik. This pertains to issuances of a search warrant as well as a warrant of arrest. Okay? So niingon ang inyong Article 3, Bill of Rights, Section 2, nga no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Okay? Okay? So, constitutionally mandated yun na nga ang warrant of arrest shall only issue upon a finding of probable cause to be determined personally by the judge. Okay? Di ba, ang purpose of preliminary investigation, as what we have discussed in the past, is only to determine probable cause. As stressed in one case, no, the investigating judge or prosecuting officer acts upon probable cause and reasonable belief, not upon proof beyond reasonable doubt. So the occasion is not for the full and exhaustive display of parties' evidence. It is for the presentation of such evidence only as may engender a well-grounded belief that an offense has been committed and that the accused is probably guilty thereof. So when all of this is fulfilled, the accused will not be permitted to cast about for fancied reason to delay the proceedings, okay? The time to ask for more is at the trial. Now, both under the 1935 and 1973 constitutions, before the 1987 constitution, maumni silang effective 35 and 73. The settled ruling of our jurisprudence, which rulings, no, the drafters of the 1987 constitution were also cognizant of and took into consideration, is that ang judge, in the determination of the existence of probable cause for the issuance of warrant of arrest, may rely upon the certification of the prosecutor or the fiscal that he has conducted a preliminary investigation and that a probable cause exists. Okay? Now, the insertion of the judge's determination of the existence of probable cause in the 1987 Constitution serves to underscore the exclusive and personal responsibility of the issuing judge to satisfy himself of the existence of a probable cause. He is proscribed, prohibited siya from delegating this task of investigation to any other person. He must do it personally. Mo na'y pasabot nga upon personal or after the examination under oath or affirmation, diba, determined personally by the judge after examination under oath or affirmation of the complainant. This only means that he must do it personally, okay? And remember that in satisfying himself, the judge, in satisfying himself of the existence of probable cause for the issuance of a warrant of arrest, the judge, following the established doctrine and procedure, may either rely upon the fiscal certification of the existence of probable cause, whether or not the case is cognizable only by the RTC, and on the basis thereof, issue a warrant of arrest, or if on the face of the information he finds no probable cause, he may disregard the fiscal certification and require the submission of the supporting affidavits and witnesses to aid him in arriving at a conclusion as to the existence of a probable cause. Okay? Kaning pag-add sa Section 2, Article 3 of the 1987 Constitution sa word nga personally after the word determined, balik ko na to, tanawa ang gibutang dre. To be determined personally, to be determined personally by the judge. Kani nga addition on the requirements for the issuance of a search warrant or warrant of arrest does not mean that the investigating judge must personally examine the complainant and his witnesses in the determination of probable cause for the issuance of warrants of arrest. What the Constitution actually underscores is the exclusive and personal responsibility of the issuing judge in such determination. Dili niya i-delegate. Okay? For that purpose, the judge is actually not required to personally examine the complainant and his witnesses. Following the established doctrine and procedure, he shall personally evaluate the report and the supporting documents submitted by the fiscal regarding the existence of probable cause, and on the basis thereof issue the warrant of arrest. Or, as what we've mentioned, if on the basis thereof he finds no probable cause, he may disregard the prosecutor's report and then require the submission of supporting affidavits and witnesses to aid him in arriving at the conclusion as to the existence of probable cause. Okay? I hope that's clear. Remember that upon the arrest, do na kay pwedeng ma-appeal, okay? Just because there's only a warrant of arrest ra ang issue doesn't mean nga ang tao ra gyud imong pwedeng ma-arrest, okay? Upon the arrest, the following may be confiscated from the person arrested. Unsa man na? Objects, subject of the offense, or used or intended to be used in the commission of the crime. Objects which are the fruits of the crime. Also, those which might be used by the arrested person to commit violence or to escape, and mga dangerous weapons and those which may be used as evidence in the case. Okay, so these are the things or objects that may be confiscated from the person arrested. Okay. Also note the underlying rule governing arrest pertaining to the prohibition against the use of violence or unnecessary force in making the arrest. Okay? The rule emphasizes that walay person ngay arrest that should be subject to a greater restraint that is necessary for his detention. Okay? Kanang mga police brutality, that's prohibited and that's protected under the Constitution, and that's also emphasized in the rules of court. Okay? Now let's go to Section 3 and Section 4, duty of the arresting officer and the execution of the warrant. Okay? Section 3 provides that it shall be the duty of the officer executing the warrant of arrest or the warrant to arrest the accused and to deliver him to the nearest police station or jail without unnecessary delay. Okay? Section 4, execution of the warrant. The head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. In case of his failure to execute the warrant, he shall state the reasons, therefore, okay? Remember, guys, that unlike a search warrant, which we will learn later on, no, next meeting mo na to discuss, unlike a search warrant, the 10-day period stated here is not the lifetime or period of enforceability of a warrant of arrest, okay? The said warrant of arrest does not become factus officio, okay, by the mere lapse of the said period, and is enforceable indefinitely until such time as the arrest of the person or persons named in the warrant has not been effected. Okay, timan ina. Kaning 10 days nga gisulti dire aning section 10 doesn't mean nga mo expire ang warrant, because ang warrant is enforceable indefinitely. Di na siya mo expire until ma-arrest ang person subject of the warrant, okay? However, within the period of 10 days, the head of the office to whom the warrant was issued must cause the execution thereof, okay? And failing which, the officer assigned therefore must make the corresponding return to the issuing judge within 10 days from the lapse of the original period. Okay? Dapat mo file siya og return. Kamong mga police that you know how it's done, diba? Unya, unless specifically provided in the warrant, the said warrant remains enforceable until it is executed, recalled, or quashed, even if it is returned and served by the arresting officer because the person named therein cannot be found. Okay? The said warrant will continue to remain on file for subsequent service. All right? So let's now go to the more interesting topic, which is warrantless arrest. Lawful warrantless arrest. Okay, that's section 5 of your rule 113. So section 5, arrest without a warrant. When is it lawful? Okay, a peace officer or a private officer may, without a warrant, arrest a person. Unsa man nga mga instances? Una, when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Okay, mauning in flagrante delicto. Ikaduha, when an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it, muning hot pursuit. And when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. In cases falling under paragraphs A and B above, the person arrested without a warrant shall be forthwith delivered to the nearest police station or jail, and he shall be proceeded against in accordance with Section 7 of Rule 112. Okay, ato na nang i-discuss gahapon. So, timan nga the general rule as regards arrests, mga searches and seizure is that no arrest can be made without a valid warrant issued by a competent judicial authority. Okay? Hence, the doctrine is that a valid warrant of arrest is required before an arrest may be made. Okay? The exception is kaning gitawag natong warrantless arrest under Section 5 of Rule 110. Okay? So, diri sa Section 5, mao ni ang mga instances where an arrest may be lawfully made or may lawfully be made without a warrant and or by a private person, in which case it is known as the citizen's arrest. Pwede po ng citizen's arrest, okay? The substantial revision of this section was effected in paragraph B, which now only requires that the person making the arrest has probable cause to believe, based on personal knowledge of facts or circumstances, that the arrestee, the person to be arrested, is responsible for an offense which has just been committed. Okay? In addition to the situations contemplated in this section, arrest without a warrant may also be validly made where a person who has just been lawfully arrested escapes or is rescued, or by bondsman for the purpose of surrendering the accused. Naman ay nana, mahitabo man na, kanang banded ang tao, nagpiyansa ba, through a bondsman, and then dili mo tunga during hearing or trial. So the bondsman can actually arrest the person of the accused in order to surrender him before the court, okay? Also, when the accused attempts to leave the country without permission of the court, if you are bailed, if you have actually posted a bail and your case is still ongoing, you are not allowed to go out of the country. Mabito na i-require ka mga na silang barangay clearance to know where are you living, where are you located, okay? Where are you residing? So if you go out of the country, you have to ask for a permission from the court. If you do not have permission from the court, pwede kang ma-arrest ka na if you attempt to leave the country, okay? Now, even in the instances not allowed by law, a warrantless arrest is not a jurisdictional defect, and objection thereto is waived where the person arrested submits to arraignment without objection. The subsequent filing of the charges and the issuance of the corresponding warrant of arrest against the person illegally detained will cure the defect of that detention. Okay? Also note that jurisprudence instructs that for a warrantless arrest of a person caught in flagrante delicto under this paragraph A, kining paragraph A, in order for it to be valid, there are actually two requisites that must concur. So mga two requisites. Una, the person to be arrested must execute an overt act. There has to be an overt act indicating that he has just committed, is actually committing, or is attempting to commit a crime. You know the concept of an overt act in your criminal law, di ba? So, para mo fall aning concept sa inflagrante delicto, dapat na two requisites. Una, the person to be arrested must execute an overt act indicating that he has just committed, is actually committing, or attempting to commit a crime. Ikaduha, kana nga overt act, such overt act is done in the presence or within the view of the arresting officer, okay? In this type of warrantless arrest, the person making the arrest himself witnesses the crime and hence has personal knowledge of the commission of the crime. Okay? So, ang example na kung pananglitan si X, nakakita mismo nga si Y ning fire og gun against Z. Okay? So, that's basically infragrante delicto. Ikaw mismo ang naka-witness, the one making the arrest, the person making the arrest, actually witnesses himself the commission of the crime. Okay? So, mao ni ang caught in flagrante delicto. Right? Ang niingon si Briano nga there's an illustration. There's a case that best illustrates an arrest in flagrante delicto. Okay? This is actually a case wherein there is a conduct of a buy-bust operation, and after that there is an arrest made. Okay, so let's try to see kuno that case, the case of People versus Collado. Okay, so unsa may nahitabo sa People versus Collado? Here si O2 Noble received information from a civilian asset that spouses Marcelino and Myra were engaged in selling shabu, and that drug users, including out-of-school youth, were using their residence in San Joaquin, Pasig City for drug sessions. A buy-bust operation team was thereafter formed, and then the asset introduced PL2 Noble to Marcelino as a regular buyer of shabu. Myra accepted the money. Si Marcelino then took from his pocket a small metal container from which he brought out a small plastic sachet containing white crystalline substance and gave it to PO2 Noble. Meanwhile, CSPO2 Cruz and another police officer went inside the house of Marcelino and Myra, where they found Apello, Cipriano, Ranada, Abache, Sumulong, Madarang, and Latario gathered around a table, littered with various drug paraphernalia, such as an improvised water pipe, strips of aluminum foil with traces of white substance, disposable lighters, and plastic sachets. A strip of aluminum foil used for smoking marijuana was recovered from Ranada. So they were arrested no after that, and then RTC found Marcelino and Myra guilty of RA 9165 and also the others, particularly Section 14 of the same law. The Court of Appeals affirmed the decision with modification that katong mga nasakpan nga nag-gather around the table were just accessories and not principals. Okay, so the issue here is whether or not irregularities attended the arrest, detention, and the procedure in handling the specimen seized from them. So, niingon ng Supreme Court na remember, the presumption of regularity in the performance of official duties must be upheld in the absence of clear and convincing evidence to overturn the same. Appellants argue that the arrest, the search, and the seizure conducted by the police officers were illegal since it was not supported by a valid warrant. They thus posit that this or their right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures was actually violated. And then further, ningon ng Supreme Court nga Section 5 of Rule 113 of the Rules of Court provides for instances of lawful warrantless arrest. Enumerate niya, okay, gibalik to niya, katong flagrante delicto, hot pursuit, or kung escape ka or being rescued, okay? And then further, ng Supreme Court, Section 5A is what is known as an arrest in flagrante delicto. And for this type of warrantless arrest to be valid, two requisites must concur. Katong ganihan, dapat na overt act. Kunya ka ang overt act is done in the presence or within the view of the arresting officer. And according to the Supreme Court, a common example of an arrest in flagrante delicto is one made after conducting a buy-bust operation. This is precisely what happened in the present case ng Supreme Court. The arrest of the appellants was an arrest in flagrante delicto made in pursuance of Section 5A, Rule 113 of the Rules of Court. The arrest was effected after Marcelino and Myra performed the overt act of selling to P.O. Noble the sachet of shabu and Ranada of having in his control the custody illegal drug paraphernalia. Thus, there's no other logical conclusion than that the arrest made by the police officers was a valid warrantless arrest since the same was made while the appellants were actually committing the said crimes. Moreover, ng Supreme Court, assuming that irregularities indeed attended the arrest of the appellants, they can no longer question the validity thereof as there's no showing that they objected to the same before their arraignment. Neither did they take steps to quash the informations on such ground. They only raised this issue upon their appeal to the appellate court. And by this omission, any objections on the legality of their arrest are deemed to have been waived by them. So if you want to raise any objections as to the validity of your arrest, you have to make it before arraignment, okay? Anent their claim of unreasonable search and seizure, it is true that under the Constitution, a search and consequent seizure must be carried out with a judicial warrant. Otherwise, it becomes unreasonable, and any evidence obtained therefrom shall be inadmissible for any purpose in any proceeding. This prescription, however, admits of exceptions, and one of which is the warrantless search incidental to a lawful arrest. Okay? The arrest of the appellants was lawful. Under Section 13, Rule 126 of the Rules of Court, a person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. The factual milieu of this case clearly shows that the search was made after the appellant were lawfully arrested. Pursuant to the above-mentioned rule, the subsequent search and seizure made by the police officers were likewise valid. Hence, ng Supreme Court, the appellant's claim of unreasonable search and seizure must fail. Okay? So, na ang source na rin no Lawful. This is from Lawful. I actually read the entire case from Lawful. So, basically, that's an example of a valid warrantless arrest in flagrante delicto under Section 5, Paragraph A. Okay? Now, let's check kung this case, Umil versus Ramos. Okay? Unsa may nahitabo ani, military agents received confidential information that a certain man, Ronnie Havillon, believed to be one of the 5 NPA Sparrows who recently murdered 2 Capcom mobile patrols, was being treated in St. Agnes Hospital for having gunshot wounds. Later on, it was found out that si Havillon is a fictitious name and that his real name was Rolando Dural. Okay? So si Rolando Dural was transferred to the Regional Medical Services of the Capcom for security reasons. Meanwhile, he was positively identified by the eyewitnesses as the one who murdered the 2 Capcom mobile patrols. In these 8 consolidated cases, it assails the validity of the arrests and searches made by the military on the petitioners, that a mere suspicion that one is a Communist Party or NPA member is a valid ground for his arrest without a warrant. So the issue here is whether or not the warrantless arrest is valid. According to the Supreme Court, yes, the arrest without warrant is justified because it is within the contemplation of Section 5, Rule 113, because Dural here was committing an offense when arrested because he was arrested for being a member of NPA, an outlawed organization where membership penalized, and for subversion which, like rebellion, is a continuing offense. And given the ideological content of membership of the CPP-NPA, which includes armed struggle for the overthrow of organized government, Dural did not cease to be or became less of a subversive for purposes of arrest, okay? Simply because he was, at the time of the arrest, confined in St. Agnes Hospital, okay? So that's section 5, paragraph A. Let's have another exception found in section 5B of the rule or of rule 113, which authorizes again a warrantless arrest. This is the hot pursuit exception, okay? Section 5B of rule 113 provides that when an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that a person to be arrested has committed it. Okay, this second instance of lawful warrantless arrest covered by paragraph B of section 5 necessitates two stringent requirements before a warrantless arrest can be effected. So if you recall earlier, ang A, kailangan to, itong inflagrante delicto, kailangan to siya overt acts and then it must be personally witnessed by the person making the arrest, di ba? Kung ang kaning hot pursuit, naapod siya gi-require nga two stringent requirements. Ha, stringent requirements. Una, that an offense has just been committed. And the person making the arrest has personal knowledge of facts indicating that the person to be arrested has committed it. Okay? Under this exception, the law enforcers need not personally witness the commission of the crime, but they must have personal knowledge of facts and circumstances indicating that the person sought to be arrested committed it. Okay? In fact, the offense was not committed in his presence, although the said offense, as required by the law, has just been committed. Okay? Lahi siya with the first paragraph because in the first paragraph, personally naka-witness man ka. Here it is not necessary that you personally witness the crime. Okay? The tenor of the rule obviously emphasizes the immediacy of the arrest reckoned from the commission of the crime. Okay? Mao ni siya ang gitawag natog hot pursuit exception. Okay? In the case of People versus Cadana, ningon na Supreme Court nga an arrest made based on information from unnamed sources a day after the crime was committed was held to be invalid. Okay? Di siya valid a day after. In Rolito Go versus Court of Appeals, ningon po ng Supreme Court, the accused was arrested 6 days after the commission of the crime. The arrest here was held invalid because the offense has not just been committed. Okay? In Posadas versus Ombudsman, ningon po ng Supreme Court, ang warrantless arrest was invalidated because it was made 3 days after the commission of the crime. Okay? It must be emphasized that the personal knowledge referred to under the hot pursuit exception does not refer to actual knowledge of the crime because the officer did not witness its commission. Okay? The knowledge referred to here is the knowledge that a crime was committed, even if it was not committed in his presence. Okay? Ang Supreme Court, iya pang gidistingo no nga under the inflagrante delicto exception, the person making the arrest himself witnesses the crime. While in hot pursuit exception daw, the person making the arrest knows for a fact that the crime has been committed. Nakahibaw siya nga na nakomiter nga crime, but wala siya kita personally, as opposed to the inflagrante delicto exception. Okay? The person making the arrest has personal knowledge of the fact that the crime was committed because at the time of the arrest, he has reasonably worthy information in his possession, coupled with his own observation and fair inferences therefrom, that the person arrested has probably committed the offense. Okay? And in fact, the arresting officer may even rely on information supplied by a witness or a victim to the crime. Okay? Also note that gi-emphasize sa Supreme Court in the case of Abilita versus Doria nga ang personal knowledge of facts must be based on probable cause, okay? Which means an actual belief or reasonable grounds of suspicion. The grounds are reasonable when the suspicion that the person to be arrested is probably guilty of committing the crime is based on actual knowledge, okay? Actual knowledge or actual facts, meaning it has to be supported by circumstances sufficiently strong in themselves to create the probable cause of guilt of the person to be arrested, okay? The reasonable suspicion must be founded on probable cause. Of course, this has to be coupled with good faith on the part of the peace officers making the arrest. Okay? And note that giklaro po sa Supreme Court nga the facts or circumstances that would lead an officer to acquire a personal knowledge that a crime was in fact committed pertain to the actual facts or the raw evidence which are sufficiently strong in themselves to create the acquired probable cause. Okay? Now, there are also several cases where in the Supreme Court nga niingon nga akan ni mo ni mga example or mo ni siya ang mga concept nga well within the hot pursuit operation. Let's take the case first of People versus Akol. In this case, two robbers divested the passengers of a jeepney of their belongings, including the jacket of one passenger. So the passengers immediately sought the help of the police officers, which form a team to track down the suspects. Now, one of the passengers who went with the responding police officers saw one of the robbers casually walking the same vicinity and wearing his jacket. So the warrantless arrest in this case, according to the Supreme Court, the warrantless arrest of the accused was sustained by them as well within the hot pursuit exception. Okay. Another case is the case of People versus Herente. Okay, in this case, the Valenzuela police station received a report of a mauling incident which resulted in the death of the victim, who received a massive skull fracture caused by a hard and heavy object. The policemen saw the dead victim in the hospital and saw the instruments of death in the crime scene. Right away, the officers went to the crime scene and found a piece of wood with bloodstains, a hollow block, and two pouches of marijuana. So a witness told the police that the accused was one of those who killed the victim. So they proceeded to the house of the accused and arrested him in some 3 hours after the alleged killing. So the Supreme Court here said that based on their knowledge of the circumstances of the death of the victim and the report of an eyewitness, in arresting the accused, the officers had personal knowledge of facts, leading them to believe that it was the accused who was one of the perpetrators of the crime. Okay. Another case where the Supreme Court said that this is within the purview of hot pursuit exception is the case of Abilita versus Doria. Here, the petitioner alleged that he was arrested based merely on information relayed to the police officers about a shooting incident and that they had, at the time of the arrest, no personal knowledge of the facts. The court found that as soon as the police received a phone call about a shooting incident, a team was dispatched to investigate. The investigation disclosed that a crime or a victim was wounded and that the witnesses tagged the petitioner as the one involved and that he had just left the crime scene. After tracking down the petitioner, he was invited to the police headquarters, but the petitioner, who initially agreed, sped off, prompting the authorities to give chase. The court ruled that the petitioner's act of trying to get away, coupled with the incident report which they investigated, is enough to raise a reasonable suspicion on the part of the police authorities to the existence of probable cause. Okay? Also, in a recent case here, the arresting officers went to the scene of the crime upon complaint of the offended party that he was mauled less than an hour after the alleged mauling. So they saw the blooded state of the victim and how the latter identified the assailants. So the accused, when confronted by the police, did not deny the mauling, although they gave another version of the incident. So these circumstances qualify as to the officer's personal knowledge of commission of the crime to justify the warrantless arrest. This is the case of Pistilos versus Generoso. Okay, so now let's proceed to Section 6 and Section 7. Okay, Section 6 is the time of making arrest. Okay, remember that an arrest may be made on any day and at any time of the day or night. Okay, any day, any time. Okay, method of arrest by officer by virtue of a warrant under Section 7. It states that when making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and the fact that a warrant has been issued for his arrest, except when he flees or forcibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. The officer need not have the warrant in his possession at the time of the arrest, but after the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as possible. Okay? So, when making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of his arrest, the fact that a warrant has been issued for his arrest. The information need not be given when the person to be arrested actually flees, forcibly resists, or the giving of the information will imperil the arrest. Okay, no? Naturally, no? Kung mo ikyas day siya upon making the arrest, maging pagyuday ka nga, oh, mao na imong kuan, warrant mo na reason, okay, sa imuhang pagka-arrest, okay? So, you have to ensure muna nga di siya maka-flee or di siya ma-resist or it will not imperil the arrest, okay? The officer did not have the warrant in his possession at the time of the arrest. However, after the arrest, the warrant shall be shown to the person arrested as soon as practicable, if the person arrested so requires. Okay? The officer assigned to execute the warrant of arrest has, after the arrest of the accused, the duty to deliver the person arrested to the nearest police station or jail without unnecessary delay. Okay? Otherwise, you'll be penalized under the revised penal code. Now, method of arrest by officer without a warrant and method of arrest by private person. Okay, Section 8. When making an arrest without a warrant, the officer shall inform the person to be arrested of his authority and the cause of the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, has escaped, flees, or forcibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. Section 9, when making an arrest, kani, this is method of arrest by private person. Ningon ng Section 9, when making an arrest, a private person shall inform the person to be arrested of the intention to arrest him and the cause of the arrest, unless the latter is either engaged in the commission of an offense, pareha na sila, no, is pursued immediately after its commission, or has escaped, flees, or forcibly resists before the person making the arrest has opportunity to so inform him, or when the giving of such information will imperil the arrest. Okay? So these sections provide for the procedure in effecting arrest with or without a warrant, or making a citizen's arrest under circumstances contemplated in Section 5 of this rule. Okay? Up next is Sections 10, 11, and 12. Okay? So, basically, these sections, okay, basahan ninyo, these sections actually provide for the permissible means and force which may be availed of for the purpose of effecting the arrest under stated situations. Okay? Kaning Section 11 and Section 12 now permit only an officer to break into a building to effect an arrest. Okay? Officer. Hence, such right is not extended to a private person. Timan ina ha, na may citizen's arrest no made by a private person. Kaning 11 ug 12, the right to break into a building or enclosure and the right to break out of it is not extended to a private person. Okay? This is only extended to an officer, a police officer. Okay? Nevertheless, a private individual is exempt from criminal liability for trespass to dwelling whenever he has done so for the purpose of rendering some service to humanity or justice. Okay? Now on to section 13. Section 13, this section regulates the method and the exercise of the right to effect a rearrest or recapture of the arrestee. Okay? The situation here differs from that contemplated in section 5C of this rule, wherein the person arrested has escaped from detention or confinement. Here, it is sufficient that the arrestee has only been lawfully arrested, okay? And this provision is in effect an extension of the rule on citizens' arrest. And then, section 14, the last section under Rule 113, the right of attorney or relative to visit person arrested, okay? Under this section, it provides that any member of the Philippine Bar shall, at the request of the person arrested or of another acting in his behalf, have the right to visit and confer privately with such person in the jail or any other place of custody at any hour of the day or night. Subject to reasonable regulation, a relative of the person arrested can also exercise the same right. Okay? So under section 20, article 4 of the 1973 Constitution, any person under investigation for a commission of an offense shall have the right to remain silent and to counsel and to be informed of such right. This right under the 1973 Constitution is maintained with further safeguards in section 12(1), article 3 of the 1987 Constitution, still the Bill of Rights, okay? And under article 125 of the revised penal code as amended by RA 1083, the accused is entitled to confer with counsel. Iyan ang katungod, okay? The said right to confer with counsel at any stage of the detention is enforceable under the penal sanctions in RA 857 on whosoever should deny the same. And such right to counsel during the custodial investigation may, however, be waived, provided the waiver is made intelligently and voluntarily with full understanding of the consequences. And remember, nga kanang waiver, the right to counsel, kung i-waive niya right to counsel, it has to be made with the assistance of counsel. Okay? Which conditions are now embodied in the 1987 Constitution. Okay? Ang kaning akong gi-mention ganihang RA 857, it was later amended by EO 155 in 1987, and it reads as follows nga any public officer or employee or anyone acting under his orders or in his place who shall obstruct, prohibit, or otherwise prevent an attorney entitled to practice in the courts of the Philippines from visiting and conferring privately with a person arrested at any hour of the day or in urgent cases of the night, said visit and conference being requested by the person arrested or acting on his behalf or by national or international governmental organization duly accredited by the office shall be punished by prison correctional. Kigi-punish pina. However, effective April 27, 1992, RA 7438 expressly repealed that law nga akong gi-mention ganiha, katong RA 857, and defined certain rights of the persons arrested, detained, or under custodial investigation with penalties for violation thereof. Okay? So, you might ask, unsa din ang custodial investigation? What is custodial investigation? Okay. Custodial examination means questioning initiated by a law enforcement authorities after a person is taken into custody or otherwise deprived of his freedom in any significant manner. Okay? Custodial investigation or examination begins when there is no longer a general inquiry into an unsolved crime, but starts to focus on a particular person as a suspect. Okay? Di na siya general inquiry, but gipukusa na ka as a suspect. That's already custodial investigation or examination. And among the rights guaranteed to the suspect is that he must continuously have a counsel assisting him from the very start of that interrogation. And that counsel has to be an independent and competent counsel. Now, you might ask, okay, let's say I'm under custodial investigation. I know someone, I know a lawyer, but the said lawyer is a mayor of the municipality where the said police station actually holds office. Okay? So under sa ana, can that municipal mayor who is my friend, can he be considered an independent and competent counsel? According to the Supreme Court, a municipal mayor cannot be an independent and competent counsel qualified to assist a person under custodial investigation, especially if conducted by the police authorities of his municipality. His powers include the use of the elements for the maintenance of peace and order, the arrest of offenders, and the bringing of offenders to justice. So his duties are inconsistent with those of his responsibilities to the suspect whom he seeks to assist. Okay? Also note that RA 7438 expanded the meaning of custodial investigation. Under the expanded meaning, custodial investigation shall now include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed, of course, without prejudice to the liability of the inviting officer for any violation of law. Okay? This means that even those who voluntarily surrendered before a police officer must be apprised of their Miranda rights. And for one, the same pressures of a custodial setting exist in this scenario. Okay? So that's the concept of custodial investigation. How about Miranda doctrine? You often hear this ba na a person arrested or even a person under custodial investigation is already entitled to the Miranda doctrine. Kaning Miranda doctrine actually originated in the America, in the USA, okay? This is the case of Miranda versus Arizona. And we have adopted this under the Miranda doctrine. This requires that any person under custodial investigation has the right to remain silent. Anything he says can and will be used against him in a court of law. He has the right to talk to an attorney before being questioned and to have his counsel present when being questioned. And if he cannot afford an attorney, he will be provided before any questioning if he so desires. And RA 7438 reinforced the constitutional mandate and expanded the concept of custodial investigation. And this means that even those who voluntarily surrendered before a police officer must be apprised of his Miranda rights. So remember, if you're a police officer, you are an investigating police officer, if you conduct a custodial investigation, if you already start questioning before doing that, you have to comply first with the Miranda doctrine. And the Miranda doctrine requires that you have to inform the person that is under custodial investigation of his right to remain silent. Okay? Nga, imo siya ingnon nga anything that you will say will be used against you in the court of law. You have the right to an attorney. And if you cannot afford to an attorney, we will provide you with one. So that's very important that you need to comply that. Okay? Otherwise, fatally defective ang imong custodial investigation and it may not be considered as admissible. Whatever admissions made during the custodial investigation may not be made admissible in court. Okay? Now, effects of an invalid or illegal arrest. What are the effects? There are actually several consequences, and among which are the failure to acquire jurisdiction over the person of the accused, ang criminal liability sa law enforcers for illegal arrest, and also any search incident to the arrest becomes invalid, thus rendering the evidence acquired as constitutionally inadmissible. Okay? It bears stressing that the illegality of the arrest affects only the jurisdiction of the court over the person of the accused. Okay? The illegality of the arrest cannot in itself be the basis for acquittal, and it will not negate the validity of the conviction of the accused. Also, even if the warrantless arrest of an accused is later proven to be invalid, such fact is not a sufficient cause to set aside a valid judgment rendered upon a sufficient complaint after a trial free from error. Okay? So that's it for Rule 113, arrest. I hope you learned something from it. I'll see you guys on the next meeting, and next meeting we will discuss searches and seizures. Thank you.